Good day, sir. We are from L1T1 and today our group will present on the legal issue arising from the case scenario of Emerald Development Sdn Bhd and Aman Build Sdn Bhd. Before we begin our legal analysis, allow me to briefly introduce our group members. Our group consists of 5 members. The first member is Chan Yen Yu, who will discuss issue 1 on frustration. The second member is Tan Hee Hin, who will discuss issue 2 on fundamental breach and termination. I am Tan Xiao Ci and I will discuss issue 3 on variation of contract. The fourth member is Lim In Hui, who will discuss issue 4 on quantum merit and payment for work already completed. Lastly, the fifth member is Tan Yuxian, who will discuss issue 5 on waiver of the time is of the essence clause. The purpose of this presentation is to analyze whether the construction contract between Emerald Development Sdn Bhd and Aman Build Sdn Bhd was discharged and what remedies are available under Malaysian contract law. In January 2024, Emerald entered into a written contract with Aman to build a 3-story commercial complex in Sungai Pechala for 12 million ringgit to be completed by 31st December 2024. The contract included stage payments, a time is of the essence clause, Emerald's right to terminate for delay, and a force majeure clause. These terms are important because they affect the parties' rights and obligations when delay, non-performance, or unexpected events occur. By August 2024, Aman had completed about 75% of the works and Emerald had paid 9 million ringgit. In September 2024, due to rising construction costs, Aman requested more time and an additional 1 million ringgit. Emerald agreed in writing to extend the completion date to 31st March 2025 and pay an additional 500,000 ringgit, provided Aman maintained reasonable progress. However, no formal supplementary agreement was executed, which raises the issue of whether the later arrangement was legally enforceable. However, Aman's progress later slowed and eventually stopped. After Emerald issued a notice, Aman replied that it was financially unable to continue. Subsequently, several flooding damaged the structure and the local authority prohibited further construction for 2 years. Emerald then terminated the contract and claimed damages, while Aman argued that the contract was discharged by frustration and claimed payment for work already completed. Therefore, the main question is whether the contract ended because of Aman's breach, frustration, or the effect of the later variation. Now, I will pass the presentation to the next speaker who will discuss issue 1. Thank you.
I am Chan Yen Yu and I will proceed with the issue 1. So the first issue we need to address is whether the contract between Emerald and Aman is discharged by frustration due to inevitable severe flooding and the local authorities' prohibition order. Under Section 57, Subsection 2 of the Contracts Act 1950, a contract becomes void if an act becomes impossible or unlawful after the contract was made, due to an event which the promisor could not prevent. This is the statutory basis of the doctrine of frustration. And for the cases, first we have the landmark case of Taylor against Cardwell. Before this case, the common law enforced a rule of absolute liability from Paradine against Jane, which meaning parties were strictly bound to perform their contractual obligations even if unexpected events made it physically impossible. In this case, the destruction of a music hall before a concert rendered the contract frustrated. It was held that if the contract depended on the continued existence of a specific entity, there was an implied condition built into the agreement. If that entity ceased to exist through no fault of either party, both parties were excused from further performance. Besides, the frustrating event must not be self-induced, as held in Maritime National Fish Limited against Ocean Trawlers Limited. Frustration must be caused by an external, unforeseen event without the fault or choice of either party. A party cannot rely on frustration if their own actions cause or contribute to the event. Finally, under Lee Seng-Hock against Fatima bin Zain, a buyer entered into a sale and purchase agreement to buy a piece of land and paid a deposit to the vendor. Before the land could be formally transferred, the Malaysian government compulsorily acquired the land. Because the vendor no longer legally owned the land, it became impossible to complete the sale. So the contract was then frustrated. The court held that the compulsory acquisition entirely destroys the subject matter. Under Section 66, the deposit was considered an advantage received by the vendor under a contract that had now become void. the vendor was legally bound to return the deposit to the buyer. Now, let's applying the principles to our facts. Firstly, the severe flooding in February 2025 destroyed substantial portions of the partially completed structure. This goes to the very subject matter of the contract. Secondly, the local authority issues a prohibition order stopping all constructions for 2 years. These events were beyond either party's control. There is no suggestion that Emirate or Aman caused the flooding or the government order. Aman's earlier breach does not automatically defeat frustration. Besides, since the contract depends on the continued existence of the building and it ceased to exist through no fault of either party, both parties were excused from further performance, as provided in Taylor against Cadwell. However, there is a complication. Aman was already in financial difficulty and had slow progress before the flooding. They had stopped work in January 2025. Therefore, under Maritime National Fish Limited against Ocean Trawlers Limited, frustration must not be self-induced. Aman cannot rely on frustration if their own prior breach contribute to the situation. So what is our conclusion? There is a strong argument that the contract was frustrated from 5 February 2025 onwards. However, there is an important caveat. Aman's antecedent breach means that Aman cannot rely on frustration to escape liability entirely. As we will see in the next issue, Emirate may still claim damages for breach that occurred before the frustrating event. Thus, the likely outcome is the contract is void for frustration from 5 February 2025. Regarding the 9 million already paid, under Section 66 of the Contract Acts and Lee Seng Hock against Fatima bin Jain, this is an advantage received by Aman under contract that has now become void. However, because Aman had already completed 75% of the work, court may order partial restitution rather than a full refund or may set off the value of work done against the amount to be returned. And that's all for the first issue.
Thank you, Yan Yu. Now I'm Tan Hin Hin and I will move on to the second issue. The issue is whether Aman Build Sdn Bhd is in fundamental breach or repudiation for failing to proceed diligently with the project despite the extension of time and additional payment arrangement. Thereby, it will entitle Emirate Development Sdn Bhd to terminate the contract and claim damages for delay, replacement costs, and loss of anticipated rental income. The relevant authorities here are Section 40 of the Contract Act, which talks about the right to terminate a contract upon repudiation or fundamental breach. It states that when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct that his acquiescence in its continuance. Now, repudiation, or better known as refusal, is also defined in the case of Rasia Munasami against Lim Tan and Sons Sdn Bhd. In this case, it was held that repudiation only occurs when a party demonstrates an absolute refusal or inability to perform their contractual obligations. Fundamental breach, on the other hand, is defined in the case of Ching Yik Development Sdn Bhd against Setapak Height Developments Sdn Bhd and Kluangwood Products Sdn Bhd and another against Hong Leong Finance and another. It was held in those cases that a fundamental breach is one that goes to the root of the contract, depriving the innocent party of substantially the whole benefit of the agreement. Last but not least, the element of time is of essence is explained in Section 56, subsection 1 of the Contract Act. The section states that where time is of essence, failure to perform within the fixed time makes the contract voidable at the option of the promisee. Now, let's apply these legal principles to the present case. First, the Aman refused to perform or disable itself from performing. So if we look into between November 2024 and January 2025, we can see that Aman's progress slowed significantly and construction work eventually ceased entirely. So Aman did not just delay his work, but he stopped it entirely. Next, when Emirate issued a formal notice on 15 January 2025 demanding that Aman resume his work within 14 days, Aman responded by stating that he was financially unable to continue the project project. This proves that he no longer can continue the project. Furthermore, despite Emerald granting the extension of time to 31st of March 2025 and promising Aman an additional 500,000, he still failed to proceed diligently. Applying the test from the case of Rasya Munasami and Lim Tan and Sons Sdn Bhd, Aman's conduct has demonstrated an absolute refusal or inability to perform his contractual obligation. The next question is whether the breach by Aman was fundamental. To answer that, first we need to look into the facts. Even though Aman had completed 75% of the work, 25% of it still remained unfinished. For a commercial complex, 25% of incomplete work is not just a minor portion. It means that the building cannot be used yet because the incomplete building is likely very dangerous. Emerald also cannot generate any rental income because of the incomplete building. Lastly, time was expressly stated to be the essence of the original contract. So, under Section 56 of the Contract Act, this makes time a fundamental element in this agreement. So, if we apply the principle of Kluang-Wood Products and Ching-Yik Development, Aman's total failure to complete this project goes to the root of the contract. Therefore, the term breach here is fundamental and Emerald will be entitled to treat itself as discharged from any further obligations. Now, since Aman has disabled himself from performing in its promise in its entirety, and the breach is also fundamental, Section 40 of the Contract Act now gives Emerald the right to put an end to the contract. So when Emerald terminated the contract and claimed damages on 10th of February 2025, it is a valid date. So moving on to the damages, for Emerald, he can claim 3 types of damages. First is the cost of appointing a replacement contractor to complete the remaining of the work. Second is the delay losses caused by the delay. Third is losses of the anticipated rental income from his commercial complex. Under Section 74 of the Contract Act, Emerald is entitled to compensation for any loss caused by the breach which arose from the breach or within the contemplation of the parties at the time the contract was made. Next, under Section 76, a party who rightfully resigns a contract is entitled to compensation for any damage sustained through the non-fulfillment of the contract. Therefore, to conclude, it is highly likely that Aman Build Sdn Bhd committed a fundamental breach and repudiated the contract by disabling itself from performing it in its entirety. So, Emerald Development Sdn Bhd rightfully terminated the contract under Section 40 and he will be entitled to claim damages for all foreseeable loss arising from the breach. That will be all from me. Thank you.
Hi sir, my name is Tan Xiaozi. I will now discuss issue 3. The issue is whether the September 2024 written arrangement is valid and enforceable, although no formal supplementary agreement was executed. The first relevant authority is Section 63 of the Contract Act 1950, which provides that where parties agree to substitute a new contract or to resign or alter the original contract, the original contract need not be performed according to its original terms. The second relevant authority is Section 64 of the Contract Act 1950, which provides that a promisee may dispense with or remit performance of a promise, may extend the time for performance, or may accept any satisfaction which he thinks fit. The third relevant authority is Section 2, subsection D of the Contract Act 1950, which states that consideration may consist of an act, abstinence, or promise done at the desire of the promisor. The fourth relevant authority is Section 8 of the Contract Act 1950, which provides that performance of the condition of a proposal or acceptance of consideration for a reciprocal promise may amount to acceptance. The fifth relevant authority is Section 10, subsection 1 of the Contract Act 1950. It provides that all agreements are contract if they are made by the free consent of competent parties for lawful consideration and lawful object and are not expressly declared void. Lastly, the case of Williams against Rolfie Bros and Nicholas Contractors Limited. In that case, a promise to pay extra money may be enforceable if the promisor obtains a practical benefit, provided there is no fraud or duress. However, this case should be used carefully because it is an English common law authority. In Malaysia, the main legal basis should still be the Contract Act 1950, especially Sections 63 and 64. Applying Section 63, the September 2024 arrangement is likely a valid variation. Emerald agreed in writing to extend the completion date to 31st March 2025 and pay an additional 500,000 ringgit, provided Aman maintained reasonable progress. Since both parties agree to change the original date and payment terms, this amounts to an alteration of the original contract under Section 63. Applying Section 64, the extension of time is likely valid because Emerald agreed to extend Aman's completion date from 31st December 2024 to 31st March 2025. Therefore, Aman may argue that Emerald cannot strictly rely on the original deadline anymore since a new completion date had been agreed. Applying Section 2 sub D, there was slightly consideration because the additional 500,000 ringgit was promised in return for Aman continuing the works and maintaining reasonable progress. Therefore, Aman's continued performance may be treated as consideration for Emerald's promise to pay the additional amount. Applying Section 8, Aman's continued work after Emerald's written agreement may show acceptance by conduct. Therefore, even without a formal supplementary agreement, Aman may be treated as having accepted the varied terms through performance. Applying Section 10 subsection 1, the September 2024 arrangement satisfied the basic element of a valid contract because there was agreement, lawful consideration, lawful object, and no evidence of defective concern. Therefore, the arrangement is likely valid and enforceable in principle. The case of Williams against Roffey Bros may also support Aman's argument. Emerald may have obtained a practical benefit from promising the additional 500,000 ringgit because Aman would continue the construction works and Emerald could avoid further delay. However, Emerald has a strong counter-argument. The additional 500,000 ringgit was conditional upon Aman maintaining reasonable progress and it was not an automatic payment. On the facts, Aman's progress slowed significantly and eventually stopped. Aman also admitted that it was financially unable to continue the project. Therefore, Emerald can argue that Aman failed to fulfill the condition for the additional payment. Although the variation may be valid, Aman cannot enforce the extra 500,000 ringgit because it failed to proceed diligently under the varied arrangement. It is also important to separate the two effects of the September arrangement. The extension of time may still be valid, but the additional payment depends on Aman fulfilling the condition of reasonable progress. In conclusion, the September 2024 written arrangement is slightly a valid variation supported by Section 63, while the extension of time is supported by Section 64. However, Aman is unlikely to claim the additional 500,000 ringgit because it failed to maintain reasonable progress. Therefore, the variation is valid in principle, but Emerald is not bound to pay the extra sum and may rely on Aman's failure as a breach of the valid arrangement. That concludes my discussion on issue 3. I will now pass the presentation to the next speaker who will discuss issue 4. Thank you.
Good evening, everyone. My name is Lim Ing Hui. For now, I will be presenting on the issue 4, which is whether the Aman built Sdn Bhd is entitled to claim quantum merits or reasonable claim compensations for the 75% of the construction work already completed, given that the contract was either terminated by Emirates or discharged by frustrations. Moving on to the relevant authorities. First, Section 71 of the Contract Act 1915 states that when a person lawfully does work for another person, not intended it to be gratuitous, and the other party enjoy the benefit, reasonable compensations may be claimed. Next, Section 66 of the Contract Act 1950, any benefit received under the contract must be restored or compensated. This section is important if the contract was frustrated by the following and government prohibition orders. The first case is Sutter against Hedges. In this case, the plaintiff agreed to construct building but abandoned the works before completion. The defendant completed the remaining work himself. The court held that the plaintiff could not claim quantum merits because the defendant had no real choice but to accept the incomplete structure already attached to the lands. This case shows that a party who abandoned work due to his own wish is generally not entitled to further payment. The next case is Haji Hasnat against the Tan Arkan. In this case, the plaintiff was prevented from completing the works because of the defendant's conduct. The court allowed quantum merits because the plaintiff was not responsible for the refusal to complete the contracts. Another important case is Kejuruteraan Elektrik Usaha Maju against the Dilamas. The court recognized that quantum merits may operate as a restitutionary remedy to prevent unjust arrangement when one party has already benefited from work completed by the other parties. Finally, in Lim Si Chong against Ong Koh Hong, the federal court held that where there is only partial performance, there is no total failure of considerations. Therefore, restitution cannot be fully claimed when substantial benefit had already been received. Applying this principle to the facts, AMAN may first rely on Section 71 because it had already completed approximately 75% of the construction works. Emirates also benefit from the partially completed commercial complex and had already paid 9 million through the first 3 certified stage payments. Therefore, AMAN may argue that it should receive reasonable compensations for the completed works. Next, if the contract was frustrated by the flooding and governor prohibitions order, Section 66 would apply. Emirates would then be required to compensate AMAN for the benefit already received before the contract became void. AMAN may also rely on Haji Hasnan against Tan Akyang by arguing that Emirates contribute to the non-completion of the project. AMAN had requested an additional 1 million due to the rising construction costs, but Emirates agreed to pay only 500,000. Therefore, AMAN may argue that Emirates partly contribute to the AMAN financial inability to continue to the project. In addition, based on Kejuruteraan Elektrik Usaha Maju against Jilamas, AMAN may argue that Emirates should be unjustly enriched because Emirates has already enjoyed substantial benefit from the 75% completed structure. However, Emirates has strong argument against AMAN claim. Following Sapter against Hedges, AMAN later stopped work completely and admitted financial inability to continue the project. Emirates had no practical choice but to retain the incomplete buildings. Therefore, AMAN's own breach may prevent further recovery under Kwartung merit. Furthermore, under Lim Swee Cho against Oh Kok Hong, Emirates had already paid 9 million and had already received substantial benefit from the completed works. Since there was only partial failure and not total failure of considerations, AMAN cannot automatically claim the remaining 3 million under the contract. In conclusion, if the contract was frustrated, AMAN may still claim reasonable compensation for the completed works subject to deductions of payment already made. However, if the contract was terminated because of AMAN's own breach, AMAN will most likely fail to recover the additional 3 million. That's all for my part.
Good morning, sir. My name is Daniel Shem, and now I'll be presenting for issue 5. The issue is whether Emerald Development Sdn Bhd, where the time is of the essence clause when it granted Aman Build Sdn Bhd an extension of time until 31 March 2025 without reserving its rights or issuing a valid notice. So for the relevant authorities, firstly, Section 56 Sub 1 of the Contract Act 1950 states that where the time is of the essence of the contract and promisor fails to perform within the stipulated time, the contract becomes voidable at the option of the promisee. Secondly, Section 56 Sub 2 of the Contract Act 1950 states that where the time is not of the essence, a delay in performance does not make the contract voidable, but the innocent party may claim compensation for any loss suffered due to the delay. Thirdly, Section 56 Sub 3 of the Contract Act 1950 states that where the promisee accepts delay performance, the promisee cannot claim compensation for the delay unless a notice of such intention is given at the time of acceptance. In Sim Chiu Huat against Wong Tat Fui, the purchaser accepted late performance and continued with the transaction without objecting to the delay. The court held that by accepting the delay and continuing the contract, the purchaser had waived the original time stipulation and could no longer rely on it to terminate the contract. In the case of Sharika Eastern Plastic Sdn Bhd against Sharika Lam Seng Trading Sdn Bhd, one party had previously tolerated delay but later sought to insist on punctual performance. The court held that once the time has been waived, a fresh and reasonable notice must be given before time can again be of the essence. So applying the law to the present facts, the original construction contract expressly stated that time was of the essence and Aman was required to complete the project by 31 December 2024. Therefore, under Section 56 Sub 1 of the Contract Act 1950, Emerald initially had the right to treat that completion as a breach that could render the contract voidable. However, in September 2024, Aman informed Emerald that construction costs had increased substantially and requested a 3-month extension together with an additional payment. Following negotiations, Emerald agreed in writing to extend the completion date from 31 December 2024 to 31 March 2025 and promised an additional payment of 500,000 ringgit. Importantly, Emerald did not issue any notice reserving its right to claim compensation for previous delays. Emerald also did not state that it intended to continue treating the original completion date as essential. Instead, Emerald accepted the extension and allowed Aman additional time to complete the project. This situation is similar to Sim Chiu Huat against Wong Tat Fui, where the party accepted delay performance without objection. Likewise, Emerald accepted Aman's delay by granting an extension and continuing the contractual relationship. Therefore, Emerald's conduct indicates a waiver of the original time is of the essence clause. As a result, under Section 56 sub 3 of the Contract Act 1950, Emerald may lose the right to the claim compensation for delay occurring before the extension because no notice was given when the delay was accepted. Furthermore, the original completion date of 31 December 2024 can no longer be relied upon as a ground for termination. Instead, the contract falls within the principle under Section 56 sub 2, where compensation may be available but the contract is not automatically voidable for the earlier delay. Nevertheless, after receiving the extension, Aman's progress slowed significantly between November 2024 and January 2025, and construction work eventually ceased entirely. Consequently, on 15 January 2025, Emerald issued a formal 14-day notice requiring Aman to resume the work. This is consistent with the decision in Syarikat Eastern Practice against Syarikat Lam Seng Trading, where the court held that a fresh notice is required to reinstate a wait time stipulation. Therefore, Emerald's 14-day notice may be regarded as a fresh and reasonable notice capable of restoring the time is of the essence requirement for the post-extension period. Accordingly, any delay occurring after the notice may amount to a serious breach if Aman fails to comply within the stipulated period. In conclusion, Emerald waived the original time is of the essence clause when it granted an extension until 31 March 2025 without reserving its rights or issuing notice of its intention to claim compensation. Therefore, Emerald cannot rely on the original completion date or claim damages for delays before the extension. However, the 14-day notice issued on 15 January 2025 may have reinstated the time is of the essence requirement, allowing Emerald to rely on subsequent delays and potentially claim damages or terminate the contract for Aman's continued failure to perform. So in conclusion, based on the analysis of all 5 issues, the contract between Emerald Development Sdn Bhd and Aman Build Sdn Bhd was most likely discharged by frustration under Section 57 sub 2 of the Contract Act 1950. This is because the government prohibition order made performance of the construction project legally impossible for a period of 2 years. Alternatively, if frustration is not established, Emerald may terminate the contract under Section 40 of the Contract Act 1950 due to Aman's serious breach and failure to continue performance. So for Issue 1, the contract was slightly frustrated by the prohibition order. For Issue 2, Aman committed a fundamental breach by stopping construction work, entitling Emerald to terminate the contract. For Issue 3, the variation agreement extending the completion date was valid, but Emerald was not legally bound to pay the additional 500,000 ringgit because Aman merely promised to perform an existing contractual duty. For Issue 4, Aman cannot claim additional payment under quantum merit because the project remained 25% incomplete and the non-completion resulted from Aman's own breach. Finally, for Issue 5, Emerald waived the original time is of the essence clause by granting an extension without reserving its rights. But the clause was slightly reinstated through the 14-day notice issued on 15 January 2025. Accordingly, Emerald is not required to make any further payment to Aman and may claim damages for delays occurring after 15 January 2025. However, Emerald cannot claim damages for delays before the extension because those delays were waived. Aman may retain the Rm 9 million already paid for work completed and accepted by Emerald, but Aman is not entitled to any additional payment or quantum merit claim. To avoid similar dispute in the future, parties should execute formal supplementary agreements for any variation, issue timely notices when granting extension of the time, include express frustration clause in a construction contract, and maintain proper record of all delay notice and communication through the project. That's all from us. Thank you.